reconstruct probably are ubiquitous, so we find them in many countries. So maybe you have some remarks on that.
I prefer to stand. For almost 50 years, I have worked on issues of indigenous and tribal peoples, beginning as a practicing lawyer in Vancouver, with cases involving hunting and fishing rights. The UN took up the issue of indigenous peoples in the 1980s. One of the major backgrounds, one of the reasons that this happened was the expansion of national economies in the period after the Second World War into hinterland areas. That is, areas in which indigenous people had not yet really been incorporated into the national society, the national economy. Tribal people survived, though colonialism was old by that point, but they survived in hinterland areas. So now the national economy wanted to build hydroelectric dams. Bangladesh was interested in, it wasn't Bangladesh then, but Bangladesh was interested in hydroelectric power for Dhaka, and so they went into the Chittagong Hill Tracts, where the people were separate racially, linguistically, religiously, and built the Kaptai Dam, which displaced 1/3 of the Chakma tribal population without compensation or systems of relocation. The province of Quebec decided it wanted hydroelectric power, and where could it get it? In the north. Well, the northern area was indigenous, Cree, Indian, and Inuit. There were almost no non-indigenous people who were living there, except for some government officials and school teachers and a few missionaries. The missionaries happened to speak English and be Protestant, which gave a whole secondary area of difference to the populations in the north. Fernando Marcos in the Philippines also wanted electricity and started building dams in the mountainous area in northern Luzon. That story was very interesting because he ran into headhunter tribes who physically stopped the process, bombing the excavation equipment which had been moved in, and those dams were never built. What happened in international law terms, though, was the development of NGOs in Europe, Northern Europe, which were concerned essentially about the stories coming out of South America, from the Amazon and forest interior. These people were very influential in terms of their relationships with their own governments. You got the production of books like A Question of Survival on Brazil, Genocide in Paraguay on the forest areas of Paraguay. This was good documentation. Anthropologists, social scientists became very key. They influenced their government. Those governments wanted the UN to do something. The UN had studiously avoided any activity on minorities. Why? Minorities are trouble. They complicate political and economic processes. Half of the countries in the world at this point in time probably have secessionist movements of some kind, or some kind of serious social and physical problems in relation populations. And so the mood in the period after the Second World War was a kind of hope that assimilation would move on and cultural difference would end. And of course, in North America, there's all sorts of memories of the models for life in the immediate post-war world, the new, nuclear family, that showed no, cultural difference. The idea of seeing countries as diverse or plural or amalgamations was resisted very strongly, and therefore the Universal Declaration of Human Rights, really one of the great achievements of the 20th century, has one major gap, and that is on minority rights. Okay. So, of course, the social scientists who wanted the UN to take up indigenous issues had a hopeless task. It could not work. Oh, but they were clever. Let us narrow down the category. We're not dealing with minorities, we're dealing with indigenous peoples. And what is the image? Well, it's the Kayapo Indians in the Amazon. It's isolated populations. And populations in which you could point to rapid depopulation by the spread of new diseases and by the rapid movement of populations into the area. Crisis situations that we have not seen in North America for 200 years were going on in Brazil. This brought a very astonishing thing. It brought a new subject matter onto the UN agenda, as you have indicated, in identifying indigenous peoples as something new, distinctive, and groundbreaking in terms of the UN. We now have declarations on indigenous rights and on minorities, meaning cultural minorities. Because indigenous broke the ground, it became possible to have work on cultural minorities in general as well. But if you look at the two documents, you find that the one on indigenous people is much stronger. The one on minorities is fairly bland in comparison. The worldviews of indigenous people and non-indigenous peoples may vary, but the worldviews of indigenous peoples varies from group to group. Some of the social scientists in Scandinavia talked about, they've read the sort of romantic views of Indians in the Americas, and they said the Sami are not like that at all. They are competitive, they are aggressive. Wow. And I've just returned from 3 weeks in Nagaland in India, where the tensions between individual villages historically are higher than perhaps anywhere else in the world at any time, because you could raid your neighbors and take a few heads, and that was the universal practice in the area. They're now all Baptists, so they don't take heads anymore. But still, you have incredible linguistic difference between villages, rooted in this past autonomous character of each community. The achievement at the UN was remarkable in the sense of working in generalities, finding a category. One of the countries that wanted desperately to have a clear-cut definition of indigenous was India. The reason they wanted it was to make it absolutely clear that they didn't have any. Indonesia also wanted it to be a term not to be used. And if we look in ASEAN, where we're located and where this program, our hosting program is located, Thailand does not use the term indigenous. Malaysia does, Indonesia does not. Philippines does. because you have a relatively large population, and while language varies a lot, the dialects vary a lot in New Zealand, you do have a single identity, and the languages are dialects of a particular Polynesian language. In Canada, where I'm from originally, the indigenous population is unquestionably indigenous, but quite varied.
Excuse me, sir, we have to hurry a little bit because we have a time program and maybe we have some other questions too.
So impossible. No one else took the floor, so I felt a need to fit in. Perhaps I can even pose a question. You told the New Zealand story, and it was very, very interesting. But I suspect that there are significant differences within the Maori population. Because one of the things that colonialism has created is an outside imperative to unify that is essential for indigenous peoples to try to survive and try to flourish within the countries where they originate. And the success of that is quite varied from country to country. So I ask you to comment on that.
Thank you very much, Professor Sanders. I hope we can invite you because I want to hear more from you. That's very interesting. And thank you for your question. I think as we heard very much from you, very much valuable input, I will directly ask Robbie and then we ask again the audience for more questions. Thank you very much.
Yeah, thank you very much for that. It's an interesting one because it's undoubtedly true that the category of indigenous is a creation, and it's a creation often from the outside, right? Legally as much as philosophically. However, it's also a self-generated concept at the same time, right? So before there was the Treaty of Waitangi, there was a Declaration of Independence a number of years before, and people who made the declaration were many of the same people who signed the treaty. And there has always been a so there was that declaration then got forgotten, because basically if you take the declaration seriously, it's the preceding document, which means that the people who signed the treaty could not have signed away their sovereignty, right? Which therefore means that New Zealand as a sovereign state is a legal myth, right? However, the idea that some Maori have always had about creating a polity and an identity as Maori has been as much a self-generating concept as it's been externally imposed. It's probably been more self-generating than anything else. In fact, the way in which at one point in the wars in the 1860s, where all the land wars are happening, a set of Maori come together and they say, look, what we need is we need a king, because we've never had a king, but look, these guys who are so strong have got a queen, so we need a king. But how they got the king was by actually employing all their scribes and seers who knew all of the very intricate whakapapa genealogies of people to find one person whose ancestral lines would capture as many people as possible, right? So they developed the notion of kingship out of a Maori cosmology, right? So, and interestingly enough, some people I know, Maori lawyers, are now trying to retrieve that Declaration of Independence because they say that the treaty, whilst it's a principle in law, it hasn't had much, it hasn't had that much of an effect in transforming the society. So they want to go back to the Declaration of Independence. And one of the ways which they're using to justify the Declaration of Independence as something which denotes sovereignty to both the outside world, but also to how they understand it in terms of what's called Tinodanga Tilaplana, which is chieftainship, which has a slightly different meaning, is by actually going back to Vattel, finding these European international lawyers and saying there's a bit in Vattel where he says that if you are a peoples and you want to put yourself on the world stage as a nation, but you don't have the political or military capacity to uphold that nationship on the world stage, it's right and proper for you to get someone who's going to be your guardian, right? A more stronger sovereign power who's going to be your guardian. And they can be your guardian until you develop the capacities which allow you to stand on your own. But that guardianship cannot be mistaken for a colonial claim of incorporation. So they're actually using international thought, European international thought, at the same time as they're actually parsing it through their own philosophies of politics and rights and all that kind of stuff. So it's a very interesting thing, and I think what we often do, especially in the Western Academy, is we too easily think that all these categories are just essentialist, or they're made up, or they're a reaction. They're like a Nietzschean kind of, slave ethics. All you can say is no, you can't say yes. Right? Actually, that's not the case at all. These are very deep-rooted traditions, and the people who are involved in it are very, very savvy about what they're doing. No lawyers, Maori lawyers I know, who took part in that, Declaration of Rights, presented themselves or represented themselves as Maori. They represented themselves as from a particular tribe.
Thank you very much. I see now 3 people raising their hands. Can you please show me again, to be very sure, Professor Warwick, as an ailment?
Maori people claim statehood. Would it be possible for them to claim a Maori state within the constitution of the New Zealand? Thank you.
Secondly, Sam Edelman, please.
Robbie, thanks for a very interesting presentation. I'm going to be slightly provocative in asking you what the role of human rights is for the Maori. Because from one perspective, it sounded to me as if you were suggesting that they want a right not to have human rights. And I just want to relate it, because these are some of the issues I'll be speaking about tomorrow. In terms of sovereignty and the aspiration to sovereignty, it's an unfortunate fact, I think, that sovereignty as an organizing principle of the international legal and political order is far more universal than human rights. And it's fascinating the extent to which indigenous peoples all over the world are aspiring to sovereignty. And this recalled something I found, a phrase that Ratna used this morning. I think it was along the lines of the aspiration to neoliberal subjectivity, which is another very, very strong contradiction so far as I'm concerned, because this is kind of liberation into neoliberal bondage. So where do human rights fit in here to the aspiration to, is it towards something beyond human rights, an idea of justice, an idea of emancipation, an idea of democracy?
Thanks a lot. Maybe now here, sir.
Firstly, thanks to Dr. Robin for the lecture. My interest is about the possessive individualism that you constructed and struck my attention. So basically, I know a little bit about Lebua and Thomas Hobbes and John Locke. It's all about the social contract and the individual give up their freedom for the security so that the something political order happen. So it's about the relationship between, mostly the way I understand it is about the relationship just want you to elaborate more on that so that I get a better understanding of this. Thank you.
Thank you. We have a last.
Can I?
You can. Sure.
It's not a question or a comment, it's just a point of information. I'm not sure if you are aware, and other friends here are aware of a very important Supreme Court of India judgment dating back to April of this year, relating to the Niyamgiri Hills and the rights of the Dogria Kondian, so-called primitive tribes, which the court held that their traditional assemblies now had a legal status in terms of their decisions as to the kind of development path they could follow. And following this decision, $2 billion bauxite mining plan by a major European multinational went down the chute. So there has been an attempt to be creative on the part of the Supreme Court of India, looking at the traditional democratic rights of indigenous peoples in their assemblies, giving these religious assemblies a legal right.
Thank you very much. I have to ask Bobby to answer very briefly because we are already over time.
Okay. Wow. God, I find it really hard to be brief. Okay. Could Maori claim statehood? As far as I understand it, they could make the legal argument, and all things being equal, they would win it. But they wouldn't get it. You know, the government.
Because they would not survive?
No, not because they wouldn't survive, but because because then the New Zealand government would fall apart. So it would be a political intervention. Of course, and this comes to the question of human rights. From what I know, the majority of Maori who are active in these things are not after secession. Right? There's one or two who are, and there's, you know, but the majority are not after secession. What they're after is something actually which is much more complicated and deeper, which is self-governance. Right? That's what they're after, and that relates to the question of human rights. I would say that as a whole, Maori who are politically inclined would be supportive of human rights. But they will first and foremost go to the treaty. It's about honouring a treaty. That's where the whole idea of rights and justice is predicated, right? So it's not actually upon a universal declaration of human rights, or that might become useful, but it all goes back to, we signed the treaty, you need to uphold it, right? And in doing that, you need to actually redress certain breaches that and consequences which came from you breaching it. That means that they have a language which is amenable to rights, but isn't coming out of that particular kind of lineage of rights, you know, Declaration, French Revolution, all that kind of stuff. The individual in the state, I think you got it. I think you got it really well. Families float around in the state of nature with Hobbes and Locke, but he has a very difficult time. They both have difficult times trying to deal with that one. But by and large, you know, for Hobbes, it's a fiction, right? For Hobbes, it's a pure fiction. The state of nature is a fiction to justify a Leviathan, to justify sovereignty, right? For Locke, he thinks, yeah, it really existed and it still exists, and that state of nature is wilderness, and that's to be claimed, right? So in this, what you have is you've got the devil in the deep blue sea. You've got, you know, one or the other. One is a profane working of God as the sovereign, which is Hobbes, live or die, right, which can be very dangerous. And the second one is basically coming out of the state of nature, the idea that anything which is not apparently owned needs to be possessed. And so what we have is we have the state and capitalism.
Thanks a lot. So I think we have to close, unluckily, because it would be very interesting to continue our discussion, but we have no time anymore. So thank you very much for your great presentation, and thank you all for your questions and your interest. And I have to close the panel. Please give him a warm applause.
Thank you, Dr. Schillian and Mr. Henning Glasser. And now, ladies and gentlemen, we as a rule, have a little break for the coffee outside. You are all welcome to the little meal and coffee outside. Thank you. So, ladies and gentlemen, we will resume right now. And the next session will be the presentation by the scholar from Singapore and Malaysia. And I have an honor to introduce them. The first one is Mr. Remy Xu Senxi, the online citizen from Singapore. And the second speaker is Dr. Rohaida Nordin from Faculty of Law, University of Kebangsaan, Malaysia. And Dr. Dak Kwong Lee will be taking the role of discussant in this panel. So I now give the floor to Dr. Lee. Ladies and gentlemen, please join me in welcoming our speakers.
Thank you, Sebastian. It's my pleasure, although not planned, to sit here. It's my pleasure to be discussing as far as I can of this panel. And I'm happy to sit here next to two experts in their fields. I would like to introduce them briefly before giving them the floor for their presentations. First of all, it is Mr. Zhu Zhengxi. He is a lawyer of Singapore, a human rights lawyer of Singapore, and a human rights activist, if I may say so. He's a senior associate of Peter Low LLC from Singapore, and he is specialized in the human rights and criminal defense litigation, with a particular interest in freedom of expression in media. He has been and is involved in many prominent cases. Actually, currently, he's representing civil society and social political blogger Mr. Lex Hao, I hope I pronounce it correctly, in the contempt court proceedings brought against him for 2 articles relating to the ongoing challenge against colonial era anti-gay laws in Singapore. Secondly, it is my pleasure to introduce you to Dr. Rohaida Nordin. She's from the Faculty of Law of University in Kebangsaan, Malaysia, from the Faculty of Law, where she teaches international human rights law, international law, and indigenous peoples. Her research fields covers not only human rights of vulnerable groups, including indigenous people, but also does her research focus on human rights education and comparative analysis between international human rights law and Islamic human rights. So I'm very pleased to be their discussant, and I would like to give the floor to Rami. Please, the floor is yours.
Thank you, Paul. This morning we spoke about the global, and in the afternoon we ventured to the cosmic. My talk is going to be rather more circumscribed to a little island state 64 kilometers from side to side, Singapore. I hope in the course of this talk you learn some lessons that might be applicable to your fields of specialization. As my government also is very keen to export their worldview around the globe, a worldview that I will shortly go into. And I hope through the course of this talk to explain to you how that worldview is increasingly being contested at a very exciting time in my country. the reason my biodata says I'm from the online citizen, but I take some pains to say I'm from a law firm called Peter Low is this. I'm a practitioner in two senses. The first as a litigator in court, that's the bottom right picture, and the top left as a human rights practitioner in the conventional sense, an activist. In my activist capacity, I run a website called The Online Citizen, which 7 years ago was one of the forerunners of independent social media in Singapore. Media in Singapore, traditional media is very tightly circumscribed. Licenses are very parsimoniously distributed. State-owned media in the conventional sense is still completely dominant. So 7 years ago I started a website called Online Citizen, and 3 years ago my government got it in their heads to gazette my website as a political association, which very tightly circumscribes the types of financing and funding we can receive, in particular funding in kind. So air tickets and accommodation conferences such as this, which the CPG has so kindly extended. So that is part of the backdrop to why I have to very selectively wear a different hat when I am overseas. Although this is my first love, social media, independent journalism. That's where I grew up. Eventually, I put on a suit and became a court lawyer. This is the hegemonic narrative in Singapore. And this is a photo taken in the wake of something you don't see quite often in Singapore, a riot. In fact, the first in over 40 years, which happened a few weeks ago in a district of Singapore called Little India. What happened was 400 Indian migrant workers and Bangladeshi migrant workers angered at one of their compatriots being run over by a bus, turned the bus over, set it on fire, and when the civil defense and the police came, proceeded to set ambulances and other cars on fire. In the wake of that, about 40 of them were charged in court, but 5 of them were summarily repatriated back to India after being cleared by the prosecution with discharges not amounting to acquittals. So the prosecuting arm of the government found that there wasn't enough evidence to charge them in court, but the Home Affairs Ministry and immigration authorities decided nonetheless to repatriate them. In the wake of outrage by civil society, this statement by our senior Minister of State was made, and it's quite characteristic of how our government thinks, that one of the most important liberties is the ability to go outside and walk around, not in fear that something's going to happen to you. That's a great liberty. So in my government's hegemonic narrative, liberty, equality, fraternity, and the liberty to walk safely in clean, sanitized streets. That was also, echoes of that are also in the Singapore report to the UN during the Universal Periodic Review. My government says, as a young city-state with a multiracial, multi-religious, and multilingual population, Singapore has no margin for error. We insist on the rule of law to ensure stability, equality, and justice. Stability and security are the prerequisites of economic growth, which in turn enables Singaporeans to be fed, housed, and educated. And this is a worldview that has been aggressively expounded in, with differing success shared around the region as well as in many parts of the world. So today I propose to share with you how this worldview is being challenged in Singapore, this hegemonic narrative is being challenged in Singapore, in 3 different fields. The first being that of the mandatory death penalty and criminal justice in Singapore. The second being freedom of speech and expression in the form of new media regulations and contempt of court. And the third in relation to equality. And the challenges are occurring in a very interesting time. The backdrop to the state's ability to perpetuate its hegemonic narrative largely comes from economic success, economic growth, which Singapore is well known for. That economic growth has coincided with a long period of one-party rule. So from 1959 to 1981, there was not a single member of the opposition in the Singaporean Parliament. In 1981, one sole member managed to break that dominant hold. He was subsequently bankrupted and has unfortunately passed away. More recently, in 2011, something very interesting has happened. Where before in Parliament of 87 seats, there were only one or two individual opposition members. In 2011, the last general election, a breakthrough of sorts occurred. 6 members of the opposition were elected, and that forms the backdrop to which a lot of the state's narrative is being challenged. That is the space within which human rights lawyers and practitioners and activists are trying to exploit to create a different worldview. So we move on to the first field, the mandatory death penalty in Singapore. If any of you have taken a plane to Singapore, you will be warned on arrival that trafficking in drugs carries the mandatory death penalty. What this means is if you are found with more than 15 grams of a Class A drug prescribed in the Schedule of the Misuse of Drugs Act, once you are found in possession, there is a presumption that you are trafficking those drugs. The judge sentencing you only has the ability to decide whether or not you trafficked. And if he decides that you have trafficked more than that amount of drugs, he has to sentence you to death. He has no discretion to pass any other form of punishment. Unfortunately, in 2007, a young man, Mr. Yong Wei Kong from Sabah, didn't get the memo. He wasn't on a plane. He arrived via the causeway from Malaysia to Singapore. He was carrying with him 47.2 grams of heroin. He was working as a kitchen hand in Sabah, and an older friend of his, who he trusted and relied upon, asked him to carry this package across the causeway. He was sentenced to hang in 2008, and his appeal was dismissed by the Court of Appeal in April 2011. So you go through the conventional court process of a high court trial, and then after that you go to the Court of Appeal, and the Court of Appeal dismissed it. The last route for him to take was clemency by the President, which in the history of Singapore has only been granted once, and never to drug traffickers. Enter the human rights lawyer. In 2011, a lawyer by the name of Mr. M. Ravi filed a constitutional challenge against the constitutionality of the death penalty on grounds of equal treatment under the Constitution. It unfortunately failed, but he relaunched another challenge on the basis that the clemency process was possibly tainted by certain statements the Minister of Law in Singapore had made. Again, unfortunately, unsuccessful. Concurrent with the challenges in court, uniquely in a death penalty case, we saw a groundswell of sympathy and support, which was drummed up by activists on social media as well as in the international press. And people started taking notice. People started asking, who is Yong Wei Kong? And traditionally in broadcast and print media in Singapore, there's a stigma attached to drug trafficking. And the column inches that are devoted to stories of drug traffickers are very small, very far and few between. so-and-so trafficked how many grams of drugs, he's been sentenced to death. What happened in the course of the constitutional challenges as well as the campaign was a humanization of who Wui Kong was, where he came from, the circumstances he was under when he trafficked, and it started getting Singaporeans to consider whether or not criminal justice really should be a one-size-fits-all, whether or not this young boy from Sabah really deserved the same type of penalty that a hardened drug kingpin would get if he had trafficked. And across Sabah and across Singapore, a petition campaign started. This is Wui Kong's family from Singapore in a very moving moment, coming to Singapore, kneeling before the presidential palace, the Istana, asking for clemency for Wui Kong. Clemency wasn't granted. The petition was rejected, and the sentence of death was affirmed. Something very interesting happened in 2012 when our government seemed to move half a step back on the mandatory death penalty. It made the mandatory death penalty for drugs a bit less than mandatory, meaning if you had trafficked in two specific circumstances, the judge would have the discretion to decide on life imprisonment instead of death. And these two specific circumstances were this: that your trafficker must only have played the role of a courier and not have been related to any other part of the supply chain for drugs. And the second, in addition to the first, is if the accused person substantially cooperates with the Narcotics Bureau. So here we see a very utilitarian carve-out of the mandatory death penalty. You see the government saying, well, if you are a trafficker, if you help us catch other traffickers, or if you give us information that leads to someone high up in the hierarchy, we might consider letting you off, right? So I guess you must be curious how the story of Wui Kong ended. Fortunately, in November this year, he was the first case to be reconsidered for resentencing under the new regime. That's his lawyer, Mr. Ravi, and that's Wui Kong's mother. When she heard the news that he was sentenced to life imprisonment instead of the mandatory death penalty. So that's one of the rare glimmers of movement, of hope in an otherwise very bleak landscape, human rights landscape in Singapore. The provisions are extremely problematic still, and there will be great difficulty in explaining to the public why a utilitarian approach to the opposition to the death penalty is not necessarily to be preferred over the previous approach. There's some progress, but there are many on death row who unfortunately did not render the type of assistance that was found satisfactory in Wui Kong's case. So that's one area where in my little abstract I say there's some movement, there's one step forward, there's some headway made. The second area on freedom of speech, unfortunately, is a field where the movement has been backwards. Freedom of speech is granted in the Singapore Constitution. The tombstone here you see was a prop at a demonstration in relation to recent amendments introduced in the Broadcasting Act. I earlier briefly sketched out the kind of restrictions that apply to my website, the restrictions on receiving foreign funding. In 2013, the Media Development Authority in Singapore, without consultation of Parliament, passed a requirement that any website, any Singapore news website that has more than 50,000 unique views a month must put up a $50,000 performance bond. and within 24 hours of a takedown notice issued by a regulator for objectionable content, has to take it down, or the $50,000 will be forfeit. Now, the definition of a Singapore news website unfortunately was crafted so broadly as to basically be of possible application to any sort of news website in Singapore. And I will read it to you for you to understand what I mean. A Singapore news program under the new regulation is defined as any program containing any news, intelligence, report of occurrence, or any other matter of public interest about any social, economic, political, cultural, artistic, sporting, scientific, and if that's not enough, or any other aspects of Singapore in any language, whether paid or free, whether at regular intervals or otherwise. But there's one exception. It doesn't include any program produced by or on the behalf of the government. Very convenient. So this was the reaction, and this was the campaign. These were the campaigns. In the wake of those new regulations, what activists did, and what I personally was quite involved in, was crafting the public messaging to explain how these regulations were very, very problematic. And that's very difficult. I mean, to an internet nerd like me, it makes perfect sense that these regulations are very wrong. But how do you communicate that beyond a niche audience, and how do you galvanize people to take to the streets to in a political culture that is still extremely conservative and extremely authoritarian? One thing we did was we had a blackout campaign with 150 websites participating, and we explained to regular bloggers who had large celebrity bloggers with large audiences that, hey, under this new regulation, you could be required to put up a performance bond of $50,000 as and when the government deems it fit. So it could affect you too. And the turnout was significant. Unfortunately, this isn't a success story. Unfortunately, the regulations still stand. The plan is to fight these regulations next year when the law is further amended. So that's the landscape of social media. And just by way of some context, as I mentioned, media in Singapore is largely government controlled, it's largely state controlled. It took my website 7 years to get a readership of about 30 to 40,000 unique views a day. That is a drop in the ocean compared to the hundreds of thousands or millions that the state apparatus reaches. But it's still significant. It was still significant enough to have made a difference in the general elections of 2011. And that's a challenge to the hegemonic narrative that the government is extremely uncomfortable with, and partly explains the regulations they've been introducing. So, far more difficult to campaign around, far more niche is the area of what is known as scandalizing contempt, or contempt of court in Singapore. Contempt of court is a very uniquely English conception. We inherited it from the English common law. In the 1900s, the Privy Council in England, hearing an appeal from Mauritius, said the law of scandalizing the courts is all but obsolete in England, but might still be necessary in the colonies incentives. This has been very unironically adopted in Singapore, where judges have actually cited this particular case for the proposition that in a small, multiracial, multi-religious country, 64 kilometers side to side, you need laws like scandalizing the court to prevent and to preserve the administration of justice. So scandalizing contempt is a particular common law concept which punishes with a possible term of imprisonment speech that is likely, that has a real risk of impeding the administration of justice. So speech that imputes bad faith, a lack of partiality of the courts, is caught in scandalizing contempt. England has recently recommended abolishing contempt of court. Unfortunately, it still persists in Singapore. This gentleman, Alan Chadwick, was charged with contempt of court in 2010 and sentenced to 6 weeks imprisonment and a fine of $20,000. More recently, this year, we got our first cartoon case. Where a cartoonist, a political satirist, was charged not just with contempt of court, but sedition. He apologized and retracted his cartoons. Unfortunately, the Attorney General's chambers didn't proceed. More worryingly, a case that is currently before the courts is that of gay socio-political activist Mr. Alex Au, who we are currently representing in relation to 2 statements made about ongoing cases. And the sting of what he said, at least the first statement, is in the first line of this. So this is a real-life specimen of what constitutes contempt, or to the prosecutor's office, what constitutes contempt in Singapore. I don't have high hopes for this new suit. He was referring to a case of unfair dismissal on the basis of sexual orientation. I don't have high hopes for this new suit, mostly because my confidence in the Singapore judiciary is as limp as a flag on a windless day. Very evocative imagery, too evocative in the view of prosecutors. He's been charged, and we will be going to court for this next year. The other statement related to a challenge to colonial era gay sex laws, which very nicely dovetails into the next section of my talk, and it's the last. The equality challenges. Again, another uniquely colonial concept that the Singapore courts have unfortunately adopted very uncritically is the anti-buggery and the gross indecency provisions in the Indian Penal Code that were originally enacted in England and then imported into Singapore. Section 377A of the Singapore Penal Code criminalizes any male person who in public or private commits or abets the commission of or procures or attempts any act of gross indecency with any other male person. The act of gross indecency, very indeterminate, traditionally in Singapore has been interpreted to apply to oral sex and anal sex, but historically can apply to anything including mutual masturbation. In 2011, despite a government promise that they would not apply this piece of discriminatory legislation, one arrest was made under this provision. One, Mr. Tan Eng Hong, was found having sex in a toilet store, in a department store, and he was charged under Section 377A of the Penal Code, which we had all thought was obsolete or was in disuse. Unfortunately, they dusted it off and they used it. What then happened was a constitutional challenge on the basis of equality. the Attorney General's Chambers dropped the charge from 377A to one of public indecency, and then tried to discontinue and strike out the constitutional challenge on the grounds of standing, on the grounds of locus standi, that there was no live issue before the courts, and therefore the challenge should not proceed. Fortunately, last year, the court granted standing to Mr. Tan Eng Hong, saying that he was prosecuted and saying that this law potentially makes individuals criminals in the privacy of their own home. A very progressive statement. And it was on the grounds of the locus decision by the Court of Appeal in Singapore that another challenge, a proactive challenge this time, was launched by these two gentlemen you see on the left-hand side of the screen, Gary and Kenneth, who have been in a loving relationship for the last 15 years. And it was decided that the community would put forward a couple to proactively attack and to challenge 377A. And the backdrop in which these challenges occurs, again, I've spoken to many of the conference, several conference delegates who have said, well, Singapore's quite a progressive place, isn't it? And if you look at how this is Singapore's equivalent of a gay parade, has grown from 2009 to 2013, one would be inclined to agree that Singapore does outwardly seem extremely progressive. This is an annual event called Pink Dot, where a pink dot is formed on our free speech corner, and you can see how the dot has grown from 2009 to 2013. And it's even internationalized, so now it's, there are concurrent events all around the world. Unfortunately, the judiciary, or at least this particular judge who heard our challenge, didn't seem to think that society was quite ready. And he says, well, you know, we're a society in the midst of change. Some changes come fast, others evolve and take time to gain a hold, to gain currency. It's not the place of the courts to decide whether or not we should repeal this particular provision. It is the place of Parliament. So we are hopeful, as this case goes up for appeal in April, that this decision will be overruled. Unfortunately, events in the region don't give us cause for hope. We hope things will change in India, that NAS Foundation will be reviewed, because that's one of the cases we are strongly relying on. And the equality challenge in Singapore remains a work in progress. So I think there I will conclude. Thank you very much for your time.
Thank you, Remy, for your highly informative and striking presentation. I would like, without delay, give the floor to Ohaya, please.
Okay, thank you, Dr. Huang. Esteemed speakers, my co-panelist, Mr. Remy, distinguished participant, ladies and gentlemen, Assalamualaikum and good afternoon to everybody. At the outset, I would like to express my sincere thanks and deep appreciation to CPG and its competent and dynamic head, Mr. Hanin Glazer, for organizing this event and inviting me to participate in this conference, and of course for sponsoring graciously and hosting me during my stay in Bangkok. Okay, through this presentation, I intend to discuss the Malaysian government perspective on the concept of human rights. With regard to sovereignty, this presentation will also analyze the legal standing of the Malaysian government view that the issue of protection of human rights is a domestic issue within its exclusive control. I'm hoping with this presentation, I can demonstrate how and why Malaysia, due to its existing human rights perspective, has been reluctant to assume legal obligation either under treaties or customary law, customary international law. Okay, to achieve the said objective, I will divide my presentation into 4 parts. Okay, first I will discuss the main features of human rights in Malaysia. Secondly, I will try to elaborate the relationship between universalism, Asian value, domestic development and authoritarian government. And thirdly, I will attempt to explain how and why it is justified for Asian values in Malaysia. Why is it justified in Malaysia to adopt Asian values to a certain extent? Okay, and if time permits, okay, lastly I will try to demonstrate or discuss the Malaysian recent performance in human rights protection. But before I proceed, okay, I have to register a caveat that, I'm here not, as a representative of the government. I'm just sharing my, observation as an academic. First of all, the first part. In Malaysia, the federal constitution does not use the word of human rights. Okay? Instead, it guarantees fundamental liberties. Alright? However, the context of human rights guarantees in Malaysia has 2 main features. Okay, first, it rejects universal human rights, okay, because of their Western values, okay, and secondly, it adopts Asian values, which appear to have their origins in the Confucian tradition. The Malaysian government, especially when I say government here, I intend to discuss, the policy and practices under the tenureship of Dr. Mahathir Mohamad and Tun Abdullah Badawi and the current Prime Minister, which is Najib Tun Razak. But the focus will be mainly on the tenureship of Mahathir Mohamad. Mahathir Mohamad viewed the conflict between Western and Asian value under international law as a conflict between universal human rights and domestic sovereignty. Okay, that's what he viewed. This conflict often arose when international legal instruments sought to impose human rights norms on local cultures. Okay, to the Malaysian government, human rights are a new form of colonialism, with the potential to destroy the inherent diversity of the cultures and move global society towards cultural homogenization. Okay? While it remains difficult to actually scholars like me, okay, and other scholars to arrive on consensus, to arrive at consensus on the substantive contents of the Asian value, okay, Malaysian perspective on human rights in terms of the content and the approach is claimed to be similar to that of many other Asian countries, reflective of Asian values that are currently culturally acceptable to Malaysia. Okay, in March 1998, when Asian head of government met in Bangkok, okay, they reached consensus in the form of Bangkok Declaration. The Bangkok Declaration recognized human rights as universal, but insisted that they be considered bearing in mind the significance of national and regional particularities and various historical, cultural, and religion background. Does it mean that's a direct denial of universality in Bangkok Declaration? The answer is no, because analysis of the instrument suggests that there is no direct denial of universality of human rights. Nevertheless, the Asian values debate is seen as a threat to universalism, and the Bangkok Declaration, a session on the particularities of human rights, indicate that universality of human rights is at stake. Because of the particularities, Malaysia, as many other Asian states, prefers to deal with human rights within its own domestic jurisdiction resisting international monitoring, refusing to become state party to most international human rights treaties. The main critique of the claim of universality in the universal human rights are an insider's method of dominant Western powers to gain indirect control and influence over the politics and economies of Asian state. And Dr. Mahathir always, not only one occasion, always regarded Western powers as engaging in what he called economic colonialism, which according to him is much more insidious than other forms of colonialism, and which have left many developing countries even more dependent on the Western power than when they were colonies. Yeah? Dr. Mahathir always drew his analogy when he said that the condition placed on IMF bailout to developing countries during the East Asian currency crisis were equivalent to economic colonialism. And at this juncture, even though he is already, retired, but he still makes similar critique. As we all know, Malaysia is now negotiating with the counterpart on the TPP agreement, and he labeled this TPP agreement as one of the economic colonization. And in 1994, Dr. Mahathir presented the opening address at an international conference by arguing that the powerful countries of Europe and North America are culturally imperialists who claim that the right to impose their system of government, their free market, and their concept of human rights on every country. What Dr. Mahathir was attempting was apparently to defend the rights of sovereignty against those human rights advocates who he claimed have no respect for independence or territorial integrity in their mission to uphold their human rights principle. Because Malaysia political system and human rights practices reflect culturally specific Asian values, and intervention by the Western powers amount to a violation of domestic sovereignty and an expression of cultural imperialism. Next, on the approach to human rights, the Malaysian government has also argued against during the premiership of Mahathir Mohamad and also Abdullah Badawi, argued that international standards of human rights are not applicable to Malaysia because of two factors. Firstly, there is an overemphasis on the rights of individual as opposed to the rights of community. Excessive individual freedom, according to the Malaysian government, leads to a decay in moral values and weaken nations, leading to the rise of new form of racism and xenophobia, manifested in violence. And secondly, international standard of human rights, for example, those contained in UDHR, also give greater priority to civil and political human rights than economic rights, and thus alien to Malaysian tradition and cultures. Anti-colonialism, the struggle for national independence and nation building, has dominated Malaysian human rights perspective. Social, cultural, and development rights have all been given greater significance by Malaysia. But although Malaysia regards all human rights as indivisible and independent, the next Prime Minister, Tun Abdullah Badawi, has stressed that the right to development is a fundamental and inalienable right, and realization of civil and political rights is impossible without enjoyment of economic, social, and cultural rights. So they put priority over this right. And that's for the first part. Now, what is the relationship between these Asian values, economic development, and authoritarian government. The concept of Asian values and its linkage to authoritarian government as a condition for economic growth in Asia have made the expression suspicious for some. Like in Malaysia, the requirement of political stability in order to achieve successful growth is often cited in order to legitimize government action. That will include the use of national law to legitimize preventive detention, restricting freedom of expression and assembly. These safeguards are required in order for the nation to maintain public order and political stability. Thus, Malaysia emphasizes stability and enforces social cohesion as an important aspect of the fundamental core of Asian values. Even the scholars were looking at the Malaysian approach on human rights, like Guy, described the Asian approach on human rights as inclusive or strong authoritarian government with less emphasis as individual right and more on the right of the community. But the problem is that, there is, however, little evidence that authoritarian governance and the suppression of political and civil rights are beneficial in encouraging economic development. The significance of economic development as a legitimate concern, arguably, now being used as a justification to deny some human rights. And in most cases, development policy becomes a source of human rights violation, especially in my context, on the rights of the indigenous people, when they're being forced to leave their land for development project or deprived of their means of livelihood. Further, the government approach to human rights in order to achieve economic development does not necessarily guarantee an equitable distribution of the benefit of such growth or development. The Malaysian government may point to the right to development, which is also an inalienable human right held by all citizens. But how the right to development of other people within the state need to be balanced against the right of the indigenous people. For example, what I'm saying is that although the economic development is being achieved, the next issue will be how the fruit of the development is to be distributed among the community in Malaysia. And evidence shows that unequal income distribution, especially between the Malay indigenous and non-Malay indigenous, have made the orang asli in Peninsular Malaysia the most marginalized people in Malaysia. The argument about domestic sovereignty by the Malaysian government and other Asian governments is in fact founded on international law principle. The UN Charter set forth the principle of state sovereignty and equality among member states and established the domestic sovereignty of the states over their internal affairs and the principle of non-interference in international affairs. So basically, this is founded in international law principle. When we have the United Nations Charter 1945, recognize that state has sovereign, and recognize the principle of non-interference. But UDHR recognize the universality of human rights. That is the argument for how to establish relationship between, Asian values and authoritarian economic development and authoritarian government. But I would like to look at these Asian values from another perspective, where it can justify adoption of Asian values in Malaysia. I personally view that Asian values in Malaysia ought not to be dismissed simply due to its its tendency to be misused by the state. Why? I submit that there are legitimate differences in values at stake. For example, in Islam, that are not merely ways of thinking about things, but are ways of living. The right to religion for Muslims best illustrate this argument. Article 18 of the UDHR provides that everyone should have the right to freedom of thought, conscience and religion, including the right to change religion. In Malaysia, the right to religion is provided in Article 11.1 of the Constitution. Having reading Article 11, it appears that the notion apostasy is not clearly provided in the provision. Thus, to include the right to apostate as part of the right to religion for a Muslim under Article 11 is a matter of interpretation of Article 11 and whether Article 18 UDHR can be used to interpret Article 11 to provide for apostasy. On this issue, okay, the Malaysian court has pronounced that apostasy is not a profession of religion and thus should not be considered as part of the right to profess a religion under Article 11.1. And in pronouncing this, the High Court, in the case of Daud bin Mahmad, did not even refer to UDHR as a guidance. Okay? Even if the High Court, in this case, were invited to apply Article 11 of the UDHR, I would reckon that it would be turned down because of the contradiction involved towards the teaching of Islam. This has been demonstrated by the Judge Faiza Tambici in the later case, Lina Joy. In this case, the court has heard the argument that Article 18 UDHR can be used to interpret Article 11 to provide for apostasy, but has rejected such argument. On this issue, okay, Donnelly takes the view that prohibition of apostasy has a deeply rooted doctrinal basis and therefore should be approached with a certain prima facie tolerance as it is a relatively isolated deviation from the international norm. The Malaysian court attitudes towards the UDHR can also be seen in few cases like Merdeka University and Malaysian and Muhammad Izam. So what I can summarize that in these two cases, the Malaysian judiciary has refused to look at international law standard, look at international law treaties, to interpret the legal provision in Malaysia. Simply, of course, they were looking at the ICCPR. Of course, Malaysia is not the party to the ICCPR, and therefore the court argued that Malaysia doesn't have Malaysia doesn't have legal obligation to refer to those treaties. Okay, that will be the end of my third part. Okay, but in this last part, I intend to actually discuss the Malaysian recent performance in human rights protection by actually looking at the Malaysian National Report, Universal Periodic Report, okay, that has recently submitted this year. Okay, before I do that, okay, I have spoken about Dr. Mahdi Muhammad, I have spoken about Abdullah Mabadawi. Probably I would like to mention a little bit about the current Prime Minister, Najib Abdul Razak. In the report, it's stressed that, claim that the Prime Minister, Najib Abdul Razak, continues to be, somebody, a leader with a strong commitment to the rule of law, to upholding respect for human rights, and a commitment commitment to continue widening the democratic space, which was initiated during previous administration. So basically, he just, continued the commitment. Malaysia accomplished its Maiden UPR in 2009. During that process, Malaysia received a total of 103 individual recommendations, where Malaysia addressed 62 recommendations, accepted outright, and another 22 recommendations were noted, and another 19, if I'm not mistaken, were clarified by Malaysia. But as I mentioned, in the Malaysian second UPR, Malaysia has Malaysia is pertinent to highlight that a number of measures taken by the government since then have in fact addressed. So basically what Malaysia claimed in the national report is that they have considered and adopted a lot of measures, responding to the recommendation made after the first UPR. Okay, among the measures that has been adopted involve the constitutional and legislative framework. The Malaysian government, in the report, recognized that the development of, this is for the first time, that Malaysian government recognized that civil and political rights in the country should keep pace with the significant progress made in economic, social, and cultural rights. Since then, the government has taken significant measures aimed to further enhancing the exercise and enjoyment of civil and political rights in the country, including the repeal of 3 emergency proclamations, which normally been referred as draconian laws in Malaysia, which been supported and maintained and justified by the ex-Prime Minister Mahathir Mohamad, and repealing of the Internal Securities Act 1960, repealing of the Banishment Act 1959, and the repealing of the Restricted Resident Act. Alright? And the security, a new law, which is called Security Offences Special Measures Act 2012, on the other hand, was enacted as a procedural law to deal with investigation of security offense. With the repeal of the ISA, the practice of preventive detention was effectively ended. The discretionary power of the Home Minister to detain a person without court order has been removed. SOSMA, the new act enacted to replace the ISA, also guarantees necessary safeguard to a detainee consistent with international human rights norms and standards, such as right to counsel and notification to family members. And with regard to the promotion and protection of the right to peaceful assembly in Malaysia, progress has been made through the enactment of the Peaceful Assembly Act 2012, which actually enacted to bring life to Article 10 of the Federal Constitution to enhance the implementation of the right to assembly peacefully as guaranteed by the Federal Constitution. Now, the question is whether the said legislative reform are sufficient. The answer is no to many NGOs, the human rights advocates, and as well as even the United Nations country team when they preparing for the shadow report, for Malaysian UPR. In the United Nations report, it stated that their concern on the new enactment was highlighted. Among others, the new Peaceful Assembly actually recognizes arbitrary and disproportionately restrict the right to assemble peacefully. Okay, they noted that the restriction ranged from a ban on a street protest and a provision of non-citizen and citizen under 21 years of age to assemble peacefully. And also there's a lot of comment. The report highlighted a lot of restriction in the new legislation. And with regard to SOSMA, okay, they noted that it allowed the police to detain a suspect for a maximum of 28 days. Remember, this is the legislation that enacted to replace the ISA that allowed preventive detention. But there's a restriction in this SOSMA where somebody can be detained up to 28 days instead of 14 days under the normal criminal procedure code. So let me conclude by saying that whether this is enough or not. So from not having anything at all, for example, from having a legislation which is draconian in nature, which allows for preventive detention, towards having a little bit of freedom, expansion in terms of enjoyment of civil and political rights, but with limitation and restriction, which doesn't make it as absolute human rights protection. Whether this is considered as an achievement or development in human rights protection in Malaysia, me as human rights educator, I see this as a development or achievement in a promotion of human rights in Malaysia. With that, I thank you for your attention.
Thank you very much, Mahela, for an interesting presentation on the position of the Malaysian government on human rights, the question of universalism of human rights. As you know, I'm not the planned discussant, and so far I was not able to prepare my part. That's why I tried just to briefly summarize and then ask a very quick question before I open the floor for questions. Remy presented us more or less skeptical picture of the situation in Singapore, where the government still holds a strong grip on power and the implementation of its policy of setting priority for development, growth, stability, law and order over human rights implementation. Human rights you spoke of, you gave us some examples where among them there were some positive signs, also negative perspectives to be expected. My question for you would be, you spoke of your own work, and you indicate also the role of media, other media, and the public. I was wondering if there's a concerted effort of concerted engagement to further challenge the official policy and the hegemonic discourse in Singapore. With regards to Rohaida's presentation, you have clearly depicted the Malaysian government's insistence on the right to organize, protect human rights or fundamental liberties in its own way, and you referred to the narrative of Asian values. I would like to ask you if you could elaborate on what is the content. You indicated that, that there's maybe a problem to confirm what is the content of Asian values, and especially what is the content of Asian with regards to its adoption in Malaysia. And this would the narrative, the hegemonic narrative in Singapore, still stick to Asian values concept, or is there any other content in this narrative concerning values and ideas? Thank you very much. Maybe I ask the presenters to respond to mine, and then we open the floor for questions.
Thank you, Kwang. I think one of the greatest challenges moving ahead in Singapore is relating the theory of human rights, or the language of human rights, to very everyday situations. And outwardly, that's challenging. It's an uphill task to say that our government hasn't delivered on the economic goods. It bases its legitimacy on its economic performance. But if you scratch below the surface, certain incidents in recent years have indicated that perhaps the depth of social stability really isn't as deep as it might outwardly seem. So last year, in December this year, around the time of November or December last year, you see that gentleman in the photo between my boss and me. He was the leader of the first illegal strike in Singapore in 30 years. A strike in Singapore is illegal if you don't give 14 days notice. A wildcat strike is illegal. And he was one of 171 migrant People's Republic of China bus drivers that walked off the job because they were being abused by their employers. And that was a learning moment, that was a teaching moment for human rights activists to say that, well, the way you treat migrant workers, or the respect, the dignity that you give them, is very much tied to the social stability. And unfortunately, that lesson hasn't been learnt, which is why we have the Little India riots by impoverished Indian and Bangladeshi migrant workers uncannily around the same time this year. And again, that's something that human rights practitioners and activists are very firmly saying, look, this isn't just a narrow issue of whether or not they were drunk, which is the hegemonic narrative now, to confine it to a very limited cause. And so the reaction from the government to the Little India riots is very telling. They say, we ban alcohol in Little India for 6 months between certain hours, and their curfew will limit the number of hours migrant workers can spend in Little India